All right, we're starting Chapter 3, Legal, in the Law Enforcement book. Unit 1, Lesson 1, Law Systems. This one's probably going to be broken up into 2 voice recordings because it's going to be so long. So we're going to start with sources of laws. The U.S. Constitution outlines the form of government Americans have established and defines the representational government and its 3-branch structure. The legislative branch is responsible for creating laws. The executive branch, which we're a part of, is responsible for enforcing laws, and the judicial branch is responsible for interpreting the laws. Constitutional law identifies the powers and limitations of each branch of government: legislative, executive, and judicial. Florida has its own state constitution, which generally parallels the U.S. Constitution. This means that the Florida Constitution affords Florida's residents the same level of rights or greater than they derive from the federal Constitution. The Supremacy Clause of the federal Constitution states that when laws conflict, federal law generally overrules state and local laws. Statutory law. It is written and enacted by Congress, state legislators, or local governing authorities in response to a perceived need. Statutory law includes criminal, civil, administrative, and regulatory law. So statutory law kind of includes all the different types of laws I'm about to explain. First being criminal law, which identifies behaviors deemed unacceptable by society. Criminal law also sets punishments for those behaviors. Ordinances. These are laws enacted by a city or county government. Local governments create ordinances that regulate matters of narrow application, such as curfews for minors, restrictions on the hours when alcohol may be sold, or parking regulations. Civil law is the legal action that a person takes to resolve a non-criminal private dispute with another person. The courts provide a forum for people to settle these disputes. Examples are child custody, landlord-tenant disputes, property boundary issues. In law, a cause of action is a set of facts sufficient to justify a right to sue to obtain money, property, or the enforcement of a right against someone. So that is a cause of action that allows you to sue for civil. Administrative law is the body of law that establishes the operations and procedures of governmental agencies. So an example of that would be the Florida Administrative Code, the FAC, would be admin law. Case law. Case law is the body of law formed by the decisions of the court system, the judicial branch. So these are decisions made by courts. Court decisions influence how you perform your duties. Once an appellate court creates a rule known as a precedent, you are required to follow that rule, and this unless a higher court changes the rule. An appellate court is responsible for hearing and reviewing appeals from cases that have already been heard in a lower court. Additionally, each circuit court ruling is binding for that jurisdiction. So again, circuit court rulings are binding for that jurisdiction. There are a variety of sources that can help you stay current in statutory and case law. This would be agency bulletins, legislative updates, and official websites, such as the Florida Department of Law Enforcement, the Florida Office of the Attorney General, and the Florida Supreme Court. Avoid obtaining legal knowledge from unofficial sources, such as newspapers, televisions, radio, unreliable websites, word of mouth. If you fail to stay up to date with changes to laws, you may risk exclusion of evidence at trial, case dismissal, administrative discipline, civil liability, or even criminal prosecution. Examples of agency policies and procedures, they are policies on wearing body cameras, the use of CEWs, engaging in vehicle pursuits, maintaining uniform standards, and following arrest procedures. All right, Lesson 2, which is constitutional law. The U.S. Constitution sets parameters within which the government operates and establishes laws. It defines your authority to act. The Articles of the Constitution. These form the Constitution's main body. Their purpose is to form a contract between the people of the United States and the legislative, executive, and judicial branches of the United States government. The Articles spell out the responsibilities and authorities of the 3 branches of government. Remember, the Articles, they form the Constitution's main body. All right, so now we're going to quickly breeze through the amendments. The First Amendment protects the freedom of speech, press, peaceful assembly, and religion, such as recording and protesting, things like that. The Second Amendment guarantees the right to bear arms. The Fourth Amendment prohibits unreasonable search and seizure and may require a warrant signed by an independent magistrate. This is obviously entry into homes, vehicles, luggages, purses, places where you have reasonable expectation of privacy. The Fifth Amendment is best known for prohibiting compelled self-incrimination. It also requires grand jury indictment for capital crimes and prohibits double jeopardy and deprivation of life, liberty, or property without due process of law. Due process means that laws must be applied fairly and equally to all people, including a person accused of a crime. There are 2 types of due process. Procedural due process, which refers to the procedures that have to be followed to protect someone's rights, and substantive due process, which is the fair and consistent enforcement of the laws. So again, to remember these, procedural has to do with the procedures. If you don't see procedures in the type of due process, just you'll know it's the opposite, which is substantive due process, which is fair and consistent enforcement. The Sixth Amendment guarantees the right to a speedy and public trial, a fair jury, an attorney, a chance to confront witnesses, and be informed of the nature of the charges. You have the right to make contact with a suspect who is represented by counsel, and you need to make sure reports and evidence are submitted in a timely manner. So, again, the difference between the Fifth and the Sixth. The Fifth has, obviously, the right to remain silent, grand jury for capital crimes, double jeopardy, and deprivation of life, liberty, and property. Where the Sixth Amendment is speedy and public trial, fair jury, an attorney, a chance to confront witnesses, and be informed of the nature of the charges. The Eighth Amendment prohibits excessive bails and fines and cruel and unusual punishment. The 14th Amendment expands the application of the Bill of Rights to the state and local governments, as well as expanding due process clause of the 14th Amendment. So to wrap these up real quick, you guys know the first, you know the second. Fourth is unreasonable search and seizure. Fifth is protect against self-incrimination and guarantees due process. The sixth, establish a right to a speedy trial, impartial jury, assistance of counsel. Eighth, cruel and unusual punishment, excessive bails and fines. 14th, establishes due process and equal protection of the law. So, again, Fifth Amendment guarantees due process, where the 14th Amendment establishes that due process. The Constitution requires you to get the right result the right way. Failure to abide by these rules may result in the suppression of evidence and confessions and civil or criminal liability towards you or your agency. Unit 1, Lesson 3, Classification of Offenses. The term offense means a breach of law and broadly describes criminal or non-criminal acts that are punishable under Florida law. Criminal offenses may be punishable by incarceration and classified as either misdemeanors or felonies. An offense for which the only penalty being a fine, a forfeiture, or other civil penalty is a non-criminal violation, also known as a civil infraction. So if you can't be put in jail and you can only be fined or civil penalty, that is non-criminal violation, which is still an offense. So just remember that an offense can be criminal and non-criminal. Ordinance violations. Just know that ordinances can be criminal and non-criminal. Then we move on to misdemeanors. A misdemeanor is any criminal offense with a maximum incarceration penalty in a county jail for up to 1 year. So remember, misdemeanors can go up to 1 year. And then you have two types of misdemeanors. You have a second degree. This is a max penalty of 60 days in a county jail or a fine of $500 or both. An example would be criminal mischief involving property damage totaling less than $200, which we just learned. Crimes against property. So, second degree, 60 days in jail, fine of up to $500 or both. First degree misdemeanor is up to 1 year in jail and a fine of up to $1,000 or both. Then we'll move to felonies. A felony is any criminal offense committed where the maximum penalty is death or incarceration in a state correctional facility for more than 1 year. We'll move to a third degree felony first. This is 5 years, a max of 5 years incarceration or a $5,000 fine or both. Felony of the second degree is 15 years of incarceration, a $10,000 fine or both. Felony of the first degree is 30 years to life, a $10,000 fine or both. And then a life felony, which is lifetime incarceration without parole, a $15,000 fine or both. And then a capital felony, which is death or life incarceration without possibility or parole. So to kind of remember, third degree is 5 years, $5,000. Second degree is 15 years, $10,000. First degree is 30 years to life, $10,000. Life felony is just life with $15,000, and capital felony is death or life. All right. An example of a capital felony is sexual battery on a child younger than 12 years by a person 18 or older. And the only way you can get death is for a capital felony, murder of the first degree. That is the only way you get the death penalty, is murder of the first degree. Lesson 4, reading and understanding statutes. Florida statutes are divided into chapters, section, and subsections. Chapters are broad topics and are broken down into sections, which are broken down into subsections. For example, a chapter could be 812, theft, robbery, related crimes, and the section is 812.014, and then the subsection would be the 1 part. Generally, everything contained within subsection 1 outlines the actual crime itself, so things that are in subsections outline the crime. subsections are broken down into paragraphs, which specify the elements or components of the crime. So let's walk through these again here. So, for example, we're looking at a section, which would be the number 812014, which is theft. The subsection here would be outlines the crime. So for theft, it would be a person commits theft if he or she knowingly obtains or uses, endeavors to use. And then the paragraph would go into more detail with the elements. So, for example, depriving the other person of a right to property or benefit from the property, appropriate the property to his or her own use. So section is the number, subsection is the 1, 2, 3, and the paragraph is the ABC. And then, of course, the chapter would just be the chapter. So, for example, chapter 812. Enhanced penalties. An enhanced penalty is a sentence that is increased from one classification of offense to a more serious classification due to a prior conviction or the serious nature of the circumstances involved. When I asked Detective Liverpool, she said an enhanced penalty is basically a reclassification. So those those two terms are interchangeable. Reclassification and enhanced penalty ends up being the same thing. So some examples of enhanced penalties are wearing a mask or a hood to conceal your identity, showing discrimination, using a weapon, taking a law enforcement officer's gun, violent offenses committed against law enforcement, corrections, state attorneys, assistant state attorneys, and judges. Then we'll move to parties of a crime. A principal in the first degree is a person who commits any criminal offense, whether felony or misdemeanor, aids, abets, counsels, hires, or persuades an offense to be committed or attempted. So that basically means you're a partner, you were the getaway driver, you helped commit the crime, you helped plan the crime. These are all examples of principal in the first degree. Then you have accessory after the fact, is a person who gives a principal any aid with the intent that the principal avoids or escapes detention, arrest, trial, or punishment. So with accessory after the fact, just remember that someone is helping somebody escape or avoid arrest. So if someone comes to you and says, hey, they're after me, I robbed the bank, please hide me, that would be an example. Family doesn't count in this situation, and if you don't know, for example, hey, can I stay with you 3 days? You don't know they committed the crime, then you're safe in that aspect. It's only if you know and you aid and abet them from evading police and arrest. Then we're going to move on to determining a criminal offense. You have to determine whether a criminal offense was committed. So you have to ask yourselves two fundamental questions. Was a crime committed, and was there criminal intent? So criminal intent is the conscious decision someone makes to deliberately engage in an unlawful or negligent act or to harm someone else. Probable cause is a fair probability or reasonable grounds to believe that someone committed a crime based on the totality of circumstances. So again, probable cause is based on the totality of circumstances and is fair or reasonable grounds to believe that someone committed the crime. Then we're going to move on to categories of criminal intent. We're going to start with general intent, is when a suspect intentionally commits an illegal act prohibited by law without considering the results of the legal act. Examples of general intent are battery, assault, rape, kidnapping, false imprisonment, and involuntary manslaughter. So with general intent, you just have to prove that they did it, and the act of doing it proves that intent. So, for example, battery, you just got to prove that they hit the person, and then that's all the intent you need. The fact that they did it means they had the intent. Then we move on to specific intent, is the intent to commit a crime and the intent to deprive an owner of something permanently. Specific intent crimes refer to an individual's state of mind at the time, and the crime is committed by the physical act. So examples of specific intent crimes are burglary, embezzlement, forgery, murder, robbery, and theft. This kind of means that they had advanced knowledge that they were going to do it. So, for example, a burglary, you have to enter the place and you then have to commit the crime. You knew what you were doing. Where embezzlement, you don't just accidentally randomly get $1 million in your bank account. You had to do the act of trying to take the money, transferring the money, things like that. Same with robbery and theft. You have to intentionally go out and do it. Then you have transferred intent, is when a crime is intended to harm one person and you accidentally cause the second person to be hurt instead. So you go to try to hit somebody, you hit somebody else, that's transferred intent. And then recklessness is imposes criminal liability on defendants when they did not intend for a behavior to cause or resulting harm. Recklessness is just basically really, really bad negligence. So an example of recklessness may be vehicular homicide. So an example of recklessness could be you driving 100 miles an hour in a school zone. That would be recklessness, and that would then be criminal. That wouldn't be negligence at that point. Negligence is the failure to behave with the level of care that a reasonably prudent person would have exercised under the same circumstances. Negligence cases do not involve deliberate actions, but instead occur when an individual or entity is careless and fails to provide a duty owed to another person. Some examples can include a person looking at their phone instead of driving and they hit somebody. Someone unintentionally hurt someone else. For example, when I go to hit you and accidentally hit somebody else, that would be negligence. So that wouldn't necessarily be criminal. That would be more civil because it's kind of like an accident. Where, like I said, with recklessness, if you're driving 100 miles an hour in a school zone, you're being extremely overly reckless, overly negligent, and your actions are going to basically cause harm almost no matter what. Where negligence is you didn't realize what you were doing. Let's see. With negligence, the behavior usually consists of actions, but it can also consist of omissions when there is a duty to act. So we kind of learned that in first aid. If you just kind of sit there and you don't give CPR, that would be negligence. Where I would say recklessness would be doing CPR in such a horrible manner that you broke all of his bones in his chest and your bone went straight to his heart. That could probably be recklessness and criminal versus negligence, just not even doing it at all. The elements of negligence, there are 4 elements here. You have a duty to act with care, breach of the duty to act, causation or proximate cause, and damages. So causation or proximate cause is the legal phrase for the link between the breach of duty and the harm caused by the damages. Then we'll move on to types of damages. You have compensatory damages, which are designed to compensate for the actual property damage, harm, or injury that the person suffers. And under compensatory damages, you have general, specific, and nominal. So general damages are those presumed to result from the defendant's actions. These include awards for pain and suffering, discomfort, humiliation, and emotional. Special damages are those actually caused. So this would be medical expenses, destruction of their property, and attorney fees. And the nominal damages are damages in name only. They are awarded when the jury believes the plaintiff's rights were violated, but there's no proof to kind of show financial harm. Then you have punitive damages. Just remember, punitive punish. Those are intended to punish the defendant and kind of make an example out of them. Then we'll move on here to standards of legal justification. So the Fourth Amendment permits an officer to infringe more on a person's right of privacy. The officer may detain the person, frisk them during an investigative stop, or arrest the person and search and seize the property. You must be able to articulate and explain your actions in legal context throughout every step of the process. Then we'll move on to types of encounters. We have consensual encounters, investigative stops, and arrests. I'm not going to go into detail on those because I think we all kind of get the idea behind those 3 by now. Mere suspicion does not grant any enforcement or legal authority, including detaining a person or conducting a search. So mere suspicion doesn't allow you to do anything besides basically just a consensual encounter. Investigative stop. I'm not going to go through that one. Just remember with investigative stop, you kind of develop that reasonable suspicion, but if you don't develop anything further and there's no cause of arrest and there's nothing to kind of make that totality of circumstances, the suspect's free to leave. Let's see what else we got here. All right, so we're going to get to our first case here, which is Illinois v. Wardlow. The case ruled an individual's presence is an area of expected criminal activity. Standing alone is not enough to support a reasonable particularized suspicion that the person is committing a crime. So this is Illinois v. Wardlow, has to do with high crime area. So just remember that how I remember it is ill people stay outside the ward. You have a lot of high crime inside the ward, an ill ward, right? So just remember that Illinois v. Wardlow has to do with high crime area. You can't arrest somebody just for being in a high crime area. Then you have the Terry stop and frisk. We all kind of know that one by now. That's Terry v. Ohio. This is only for weapons. There are 2 elements required for a lawful pat-down. They are the person is lawfully detained based on a reasonable suspicion, and the officer has reasonable suspicion to believe that person possesses a dangerous weapon. A frisk is not restricted to a person's body. All right, then we're going to move on to Mackey v. State, which determined that simply seeing a partially concealed firearm does not, standing alone, constitute reasonable suspicion or justify a frisk, since many people may lawfully possess a concealed firearm. So this one is, a lot of people say, you can see my Mac gun, or Mac can see my key. This has to do with a partially concealed firearm, however you want to memorize that. It's basically a firearm that's visual, does not give consent does not allow you to search. Then move on to the plain touch and feel doctrine. This rule allows the officer to seize the contraband even if it does not feel like a weapon. So if you're doing a pat down and you plain touch and you know it's contraband, then you know it's illegal. You can take it. Same with the field doctrine. Contraband is anything that is illegal to produce, possess, or transport. Plain touch feel does not permit any manipulation or groping of the object in an effort to identify it as contraband. So when you're doing a pat down, you can't be sitting there digging in and feeling by groping or manipulating the item. Then we'll move on to the officer must be able to articulate that based upon their training experience, they immediately recognize the item as contraband, which is Minnesota v. Dickerson. So this, to memorize this one is, can you see my dick son? Articulate based on experience and training that you can recognize it. So that's Minnesota v. Dickerson. The duration of a Terry stop is limited to the time reasonably necessary to accomplish the purpose of the detention. And we'll pause it there before we start our next episode. All right, this is the second half of Chapter 3. We're going to jump right into pretext stops, which are pulling someone over for a traffic infraction with the intent to get into their car. These stops are called pretext stops because the officer stops the vehicle due to an equipment violation but really wants to investigate other more serious criminal activity, which makes us jump to Wren v. U.S., which addressed pretext stops and kind of gave us that right. Let me see in my paper if I have any things to remember. Wren v. U.S. I don't think I do. I think that's the one. Wren, pretext stop. You just got to remember that one straight up. Then we'll move to arrest. You must always have probable cause that a person has committed or is committing a crime in order to initiate arrest. We know that. Probable cause is the standard of justification required to make an arrest or conduct a search. Then we have probable cause, the fair probability or reasonable grounds to believe that a crime has or is being committed. Then we'll move on to Draper v. U.S. So Draper v. U.S., they are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. Draper v. U.S., it defines probable cause. We're not legal technicians. Info from a source, from a confidential source or a source that is reliable is sufficient for probable cause. Then we move on to Illinois v. Gates. Probable cause is a fluid concept based on the assessment of probabilities in particularly factual context, not readily or even usefully reduced to a neat set of legal rules. So with Illinois v. Gates, how I remember this is all the ill people stay behind the total perimeter of the gate, and this has to do with totality of circumstances. So ill people stay behind the total perimeter of the gate. That is totality of circumstances. Then we move on to developing probable cause. We see Illinois v. Gates again, which established the totality of circumstances standard of probable cause, which I just mentioned. So Illinois v. Gates, totality of circumstances. All right. Your knowledge, training, and experience will assist you with evaluating the totality of circumstances. Then we move on to proof beyond a reasonable doubt. Proof beyond a reasonable doubt is the standard used to determine if a criminal defendant is guilty. We do not use this. This is for the courts, but it's in here as a definition. So it's a standard used to determine if a criminal defendant is guilty. Now we move on to the Fourth Amendment guarantees. The Fourth Amendment of the Constitution guarantees the protection of people from government intrusion into areas where they have a reasonable expectation of privacy. A search occurs when an officer intrudes into a place where a person has a reasonable expectation of privacy. A seizure occurs when an officer affects a person's right to have or control their property, usually by physically taking it. A seizure is also a physical arrest or detention. So with the Fourth Amendment, when it comes to search and seizure, you have to have three things. You have to have government, you have to have a reasonable expectation of privacy, and you have to have the intrusion on that expectation of privacy. That would then conduct a search. The Fourth Amendment generally requires officers to obtain a search warrant before intruding into a place where an individual has a reasonable expectation of privacy. Officers should always first obtain a search warrant when it is possible and practical. A search warrant is a court order that authorizes law enforcement to conduct a search and seizure. To be valid, a search warrant must meet all of these legal requirements. It must be authorized and signed by a magistrate or judge. It must be based on an affidavit that states sufficient facts to establish probable cause that evidence of a crime will be found in place to be searched. The basis of the information in the affidavit must come from reliable sources. And the affiant, which is the person who swears to the affidavit and signs it, may be anyone, but the person serving the warrant must have jurisdiction over the place chosen for the search. So remember that the affiant on a search warrant would be you, the officer. So again, with a search warrant, that's government intrusion and reasonable expectation of privacy. So then we'll move on here to probable cause required. The law presumes that a search without a warrant is invalid. However, there are a number of exceptions that require probable cause. So if something's in plain view, if it's a mobile conveyance, and if it's exigent circumstances, you don't need a search warrant. And remember, with exigent circumstances, you have destruction of evidence, fresh pursuit, and an emergency scene. So we'll start with plain view. The officer has to be lawfully present in the place where they see the item. The item has to be in plain sight, and the officer has probable cause to believe that the item is contraband or criminal evidence. That is plain view. So then we move on to Sawyer v. State. A police officer saw a white pill on the console of a car, thinking it was ecstasy, and seized it. Basically, this showed that it was not immediately apparent upon first sight, so the evidence was not permitted. And with Sawyer v. State, how I memorized this one was, I saw your pill on the console. So that's how I saw it. Basically saying with this one is you have to know that it is contraband, and just pills by themselves is not apparent. You know, what was on the pills that you saw, what was the totality of circumstances, etc. Then we'll move to mobile conveyance. Vehicles and other mobile conveyances must be licensed, registered, insured, and are easily moved. You must have probable cause to search a vehicle. Then we move on to the Carroll Doctrine here under mobile conveyance, a name for the case of Carroll v. U.S. The scope of the search under the Carroll Doctrine extends to the entire vehicle and to all containers where the evidence could reasonably be found. So the Carroll Doctrine is the scope of the entire vehicle's scope of search. Then we move on to U.S. v. Ross. This justifies probable cause in the search of a lawfully stopped vehicle to include the search of every part of the vehicle and its contents. So this is kind of like the umbrella one that covers all probable cause on vehicle searches. And then again, the Carroll Doctrine has to do with the scope of your search. Then we'll move on here to, actually same topic. Courts have held that it is not a search to use a certified police canine to detect odors by going around the exterior of the car. It just has to be completed before the end of the traffic stop, and you cannot extend that traffic stop. We'll move on to exigent circumstances. Exigent circumstances are certain emergencies, such as the case of evidence and destruction, an emergency scene, or fresh pursuit that justifies a warrantless entry. So with exigent circumstances, again, we got three of them. The first one is destruction of evidence. Hornblower v. State justifies probable cause and search and seizure without a warrant, including entering a home when there is a detection of noise or scurrying activity and possible destruction of evidence. So when it comes to destruction of evidence, you have to know Hornblower v. State. And how I remembered Hornblower v. State is you're blowing the evidence away. So when you see Hornblower v. State, you're going to know you're blowing away the evidence. That is destruction of evidence. Then we move to fresh pursuit. This is the immediate and continuous pursuit by officers of a suspect who is fleeing to avoid arrest. A fresh pursuit is not restricted to a vehicle and applies to every mode of transport, including foot and bicycle. The officer may leave their jurisdiction to arrest the suspect if they are in continual fresh pursuit. Fresh pursuit, you need three conditions when they're entering a residence or a private place. Probable cause that the suspect committed a serious crime, so obviously it can't be some dumb misdemeanor, it has to be serious crime. And immediate or continuous pursuit, you have to be continually going after them. And probable cause that the suspect is actually in that residence that you're entering without a warrant for. Then we go to emergency scene. When you think of emergency scene, think of Siebert v. State. And with emergency scene and Siebert v. State, I remember that by saying Siebert is trying to kill himself. So Siebert, he's trying to kill himself. You know that Siebert v. State, that is an emergency scene where, with this case, the person was trying to commit suicide. The officer saw that, and they went in based on exigent circumstances. You are allowed to conduct a protective sweep to make sure there are no more victims and that the assailant is gone. To search a crime scene further will require a warrant for a valid exception. All right, then we move on to probable cause not being required. So these four things you do not need probable cause instead of the search warrant. So one, consent. If you ask, you can search whatever you want. Inventory, not really considered a search, but when you inventory, you don't need probable cause. Administrative searches, so if they wanted to search your backpack at the school, or if a stadium wanted to search the lockers, that would be an administrative searches. You don't need probable cause. And then you have an incident to arrest. Once you arrest somebody, you have an incident to arrest, you can search that area. So the first one being consent. The consent is knowing and voluntary, and the person giving consent has the authority to do so. And then, of course, any evidence you find from it would be valid. Consent may be obtained verbally or in writing. Implied consent includes searches of airline passengers, searches of patrons attending sporting events, and searches of visitors to courthouses or other governmental buildings. Basically, you're consenting because you know you're going to be searched there. However, a search may not be done by consent of one co-tenant if another co-tenant is present and objects to the search. So if there's two people in the house, whether it's husband and wife or co-tenants, and if they're both there and one says no and one says yes, you can't go in. If they both say yes, you can. But what you could do is if the one who's saying no, he leaves, and the person who's there says yes, if the person is not there, you are allowed to search. And then, remember, you can also search general areas. So with the co-tenant one, you couldn't search that co-tenant's room, the one who said no, but you can search the general areas, and then, of course, the person who said yes. When you think of consent, think of Georgia v. Randolph. The passenger cannot consent to a search of a vehicle. So if it's my car and my friends, my buddies in the next seat, my buddy can't consent to that. And how you would remember that is Georgia v. Randolph. Rudolph is a passenger of Santa's sleigh and cannot give consent. So Randolph, Rudolph, that's how you remember consent. Then move on to inventory. To impound means towing a vehicle out the direction of law enforcement. Any evidence or contraband found during an inventory may be used against a defendant in court. Number 3, administrative searches. Subjects of these types of searches include students, public schools, people in government offices, government property, such as desks, lockers, and vehicles, people engaged in certain businesses or licensed activities, and people on probation or parole. You do not require warrants in these type of situations. Then we move on to 4, incident to arrest. When a person is lawfully arrested and taken into custody, they may be searched without a warrant. This is called a search incident to arrest and is reasonable under the 4th Amendment. When you think of incident to arrest, think of U.S. v. Robinson. 2 historical rationales for the search incident to arrest exception are 1, the need to disarm the suspect to take them into custody, and 2, the need to preserve evidence for later use at trial. This is incident to arrest. This is U.S. v. Robinson. And to remember U.S. v. Robinson, I specifically remember it by U.S. v. Robinson, the 2 rationales, incident to a search from robbing my son. So that's how I ended up memorizing this one. If anyone has other ways to remember it, that's cool, but that's how I was able to remember this one. Incident to arrest from robbing my son, that's U.S. v. Robinson. All right. An officer may not conduct a search incident to arrest when the officer issues a traffic citation or a notice to appear. So if you do a notice to appear or you're just giving someone a traffic citation, that is not an incident to arrest. An incident to arrest must be a physical custodial arrest. Now we move on to a bunch of case laws here. So we have Chimel v. California. This is defined the scope of a search incident to arrest as the arrestee's person and the areas within the arrestee's reach. So that's how you remember Chimel v. California is within the reach. How you can also remember is you hear a chime, Chimel v. California, and you reach for my phone. So it's whatever you have within your reach. Then we have Thornton v. U.S., which clarifies that a search incident to arrest may also include the vehicle in which the arrested person was a passenger just before the arrest. How I remember this one is... Let's find Thornton here. Thornton v. U.S. You go back to a car to find a thorn on my tire. So that's how I remember that one is finding a thorn on your tire. You go back to the car. You can search that passenger spot where they were just at. Then we move to New York v. Belton. The scope of a vehicle search incident to arrest includes the entire passenger compartment and all contents located therein, locked or unlocked. How I remember New York v. Belton. How I remember this one is my belt on restricts movement to my compartment only. So when you have your belt on, you can only search the compartment around you. Then we have Arizona v. Gant. This has to do with the arrestee being unsecured. You can search only close to the person. And obviously when there's no drugs involved. Because if there's drugs involved, you can search the entire car. So Arizona v. Gant has further refined the scope of search incident to arrest situations involving vehicles. Officers may search the passenger compartment of the vehicle only when the arrestee is unsecured and the passenger compartment is within reaching distance of the arrestee, or it is reasonable to believe the vehicle contains evidence of the crime. So, for example, if you are getting ready to arrest somebody and you're pulling them out of the car, but you're kind of detaining them right there at the door, you could immediately put your head in and check around the door, check around the seat, up around the console, as long as they're there. Once you take them to your patrol car, they're no longer near there. That doesn't apply. Again, that's Arizona v. Gant. I don't know if I have a memory for that one. Let's see how to memorize Arizona v. Gant. Oh, yeah. Okay, Arizona T and a cup holder can only be reached if you're not cuffed. So that's how you remember Arizona v. Gant. You got Arizona T and your cup holder, and you're only able to reach that if you're not cuffed and you're within that reach. Then we have abandoned property and open fields. With an abandoned property and an open field, you have no right to a privacy because it's abandoned or it's open and anybody can walk around. The U.S. Supreme Court has made a distinction between the curtilage, which is a space of ground and outbuildings immediately surrounding the structure of someone's home, and an open field. So basically, if it's someone's curtilage, they have a reasonable expectation of privacy, and that would be considered burglary. So that's the immediate area around the house and the buildings that are on that immediate area. Then we move on to the scope of searches. When you're searching, you're looking for contraband, dangerous weapons, evidence, suspects, items used to commit a crime, objects obtained, and items defined by Statute 99933, search and inspection warrants. The Florida Contraband Forfeiture Act. Forfeiture is a civil proceeding in which the law enforcement agency asks the court to transfer ownership of the property from the defendant to the law enforcement agency. Forfeiture deprives a person of interest of their property, and this is the Florida Contraband Forfeiture Act. Now we're going to move on to Unit 2, Lesson 4. Chapter 790 of the Florida Statutes addresses lawful ownership, possession, and use of firearms and weapons in the state of Florida. A person younger than 21 may not purchase or transfer ownership of a firearm from a manufacturer or dealer. So Chapter 790 has to do with lawful ownership of weapons. A person younger than 21 may own or possess a firearm that has been given to them as a gift. A person younger than 21 can also buy a firearm from a private property. However, it would be a criminal offense for a person to sell or otherwise provide a firearm to someone younger than 18 if it is sold or provided without consent from the minor's parents or guardian. So remember, if you're younger than 21, you can be given it to as a gift. But if you're younger than 18, it has to be with consent from the minor's parent or guardian. And then, of course, if you're younger than 21, you can't purchase or transfer ownership through a dealer or manufacturer. Section 394.463 of the Florida Statutes authorizes a law enforcement officer taking someone into custody for involuntary examination under the Banker Act to seize and hold any firearm or ammunition the person possesses. All right, then we have the 17 exemptions to carrying firearms. I'm not going to list them all, but some of the kind of basic ones are officers, employees of the state, sheriffs, marshals, prison or jail wardens. My suggestion with memorizing these are just anything that seems kind of weird and obvious. Like a person firing weapons in a safe and secure indoor range. Obviously, you don't need a concealed license or anything along those lines. Florida law requires a person to obtain a concealed weapons or firearms license to carry a concealed weapon or firearm. This is no longer the case, so I'm not going to go into this in too much depth because of the new curriculum update. So there are some places where you cannot carry concealed a weapon, even with a permit or without a permit. Any place of nuisance, police, sheriff, patrol, highway station, prison or jail, courthouse, courtrooms, polling places, legislative or committee or meetings, school, colleges, or professional athletic events, elementary, secondary school, a career center, any place that serves alcoholic beverages as their main way of making money, college or university facility, the inside of a passenger terminal and sterile area of any airport, and any place where the carrying of firearms is prohibited by federal law, such as like a post office and federal grounds and things like that. So then we move to stops and concealed weapons. So 3 things you need to know. The weapon needs to be securely encased. It needs to be not readily accessible for immediate use. And it needs to be possessed for a lawful purpose as defined in Chapter 790. All right. Then we move on to the Law Enforcement Officer Safety Act. The Law Enforcement Officer Safety Act is a federal law that allows qualified and retired law enforcement officers to carry a concealed firearm in any jurisdiction in the United States, regardless of state or local laws. And to comply with this law in order to carry, you have to have 2 forms of documentation on you at all times. Photo identification issued by the agency for which they are currently employed or were separated from, and documentation which certifies that the officer has met within the past 12 months the active duty law enforcement standards for qualification for a firearm of the same type of the one they are carrying. Then you have reciprocity. The Florida statutes allow officers in Florida to recognize concealed weapons license issued by another state. If the other state agrees to recognize Florida concealed weapons license, this principle is known as reciprocity. Then we have a risk protection order. A risk protection order, an RPO, is a court order that temporarily restricts a person's access to firearms for up to 1 year in situations where they pose a significant danger to themselves or others by having a firearm or ammunition in their custody or control, or by purchasing, possessing, or receiving a firearm or any ammunition. There's 3 rules to that. You must have an affidavit made under oath stating these specific statements. Identify the quantities, types, and locations of all firearms, and identify whether the person has a known existing RPO already. All right. Then we'll move on to laws of arrest. But you know what I might do is I might close up this, and we'll do one more recording since we're at 20 minutes. We got one more. Stay tuned. All right, let's wrap it up. This is the 3rd section of Chapter 3, Unit 2, Lesson 5, Laws of Arrest. An arrest is depriving a person of their liberty by legal authority. Arrest with a warrant, and you can arrest without a warrant. An arrest warrant is a court order authorizing and requiring law enforcement to take the individual named on the warrant into custody to answer for charges specified in the warrant. Remember that an arrest warrant is also a pickup warrant. That would also be, or a pickup order is also an arrest warrant. So when you remember arrest warrants, think of Stiegel v. U.S., which is entering a third-party residence. So how I remember this one with Stiegel v. U.S. is that Stiegel's house, not yours. And basically this is saying to enter a third party's residence to arrest a subject named in the arrest warrant, officers must obtain a search warrant to go into someone's house. So if my buddy has an arrest warrant, his name is Anthony. If he runs into my house, officers can't just barge. If they know he's in here, they can't just come in here. They'd have to get a search warrant to search my house, followed by the arrest warrant to arrest that person. And that is Stiegel v. U.S., and I remember that one is this is Stiegel's house, not mine. Then we move on to warrantless arrests. There are the 16 misdemeanor exceptions, which I think now it's 15 because one of them was carrying a firearm and unlicensed carrying of a firearm. So I guess that's not a misdemeanor exceptions anymore, so there's really 15. So if that comes up on the test, hopefully they don't ask whether it's 15 or 16. I'm going to go through these 15 real quickly. Carrying a firearm in violation of an injunction, battery, retail theft, traffic offenses related to crash investigations, unlicensed carrying of a concealed weapon, disorderly conduct on premises of establishment, theft from a dining or lodging establishment, trespass on school grounds, possession of cannabis less than 20 grams, stalking, transit fare evasion, criminal mischief, trespass on certain properties, acts of domestic violence, violation of injunction for protection, and sexual cyber harassment. Those are the 16 misdemeanor exceptions, which I think are 15 now. Then we have a notice to appear. A notice to appear is a written order that may be issued by a law enforcement officer in lieu of physical arrest, requiring a person accused of violating the law to appear in court at a specified date and time. For misdemeanor offenses, municipal or county ordinance violations, and criminal traffic violations. So that is the only time when you can give out notices to appear. Misdemeanors, ordinance violations, and criminal traffic violations. Remember that with a notice to appear, if the accused refuses to sign the notice to appear, you have to arrest them because an NTA needs a signature. Probable cause affidavit. A probable cause affidavit, also called an arrest affidavit, is a sworn written statement by a law enforcement officer establishing certain facts and circumstances to justify an arrest. Remember that you can't issue an NTA if you can't verify their identity. The officer has reason to believe that if you let them go, they will do more bodily harm and hurt more people. The officer believes that domestic violence may have been involved, because if it's domestic violence, you have to arrest them. The accused has no ties with the jurisdiction. So if they live in, Washington, the state of Washington, and you're in Florida, they're not going to return for their court order. So you would arrest them. You would not give them an NTA. If they have a warrant, you're not going to give them an NTA. If they have previously failed to respond to an NTA, then obviously you're not going to give them another one. You're going to arrest them. Unit 2, Lesson 6, Use of Force. Objective reasonableness. An officer's use of physical force is restricted by case law, statutes, and agency policy. Use of force can be defined as the effort an officer has to use in order to get an unwilling subject to comply to their lawful commands. It is unlawful to go beyond the force that is necessary in any given situation. Use of force can include basic physical restraint, less lethal force, and deadly force. These are the 3 types of force that you can use. Basic physical restraint, less lethal, and deadly. Chapter 776.06 of the Florida Statutes define deadly force as any force that is likely to cause death or great bodily harm, and this should be a last resort when all de-escalation tactics fail. Objective reasonableness asks, would a reasonable officer have used force in a similar circumstance? It also asks, were the officer's actions reasonable under the given circumstances? So then we go to Graham v. Connor. Just remember that Graham v. Connor is use of force. You can remember that as, Connor smashing graham crackers. Just remember when it comes to any use of force, this is Graham v. Connor. This has to do with the orange juice, where totality of circumstances showed that, any officer would have thought this person was robbing the convenience store. Then we move on to Tennessee v. Gardner. How I remember Tennessee v. Gardner is 10 IC, I shoot my shot, and this has to do with fleeing felons. So 10 IC, I shoot my shot, fleeing felons. The court's test for the use of deadly force in making an apprehension is 1, probable cause of a felony involving infliction or threat of serious bodily harm. 2, deadly force is necessary to prevent the escape. 3, the officer provides a warning if feasible. And 4, probable cause exists that the felon poses a threat of death or serious bodily harm to officers or other. So you can only shoot a fleeing felon if basically the crime they committed is really bad and you think they're going to go out there continually hurting more people. Florida statutes on use of force. Tennessee v. Gardner regarding the use of force is apprehending a fleeing felon. That is 77605. So 77605 is fleeing felon. 77606 is deadly force. And 7760... what's the other one? 07... has to do with in reference to actual escape from custody by law enforcement of a correctional facility. So 77607 is basically fleeing a jail. 77606 is deadly force, and 77605 has to do with fleeing felon. All right, Unit 3, Lesson 1, Types of Liability. Liability issues may arise if you improperly perform a task or do not perform a task that you should have performed. 2 types of liability are criminal and civil. Criminal liability occurs if an individual is found guilty of committing a crime and is sentenced to incarceration or other penalties. Civil liability is a responsibility for a wrongful act or an omission that injures a person or property and most often involves negligence. So again, negligence is usually civil, not criminal. So criminal liability is you're found guilty of committing a crime. Civil liability is a wrongful act or omission, usually monetary penalties. Then you have torts. A tort is a civil wrong in which the action or inaction of a person or entity violates the rights of another person or entity. These can be intentional, such as battery or false imprisonment, or unintentional, such as negligence. Acts that lead to civil liability. The most common types of civil liability are related to arrests, searches, use of force, administration of first aid, and operation of vehicles. The same unlawful acts that result in civil liability may also subject the officer to criminal charges. The term omission means neglecting to perform what the law or duty requires. Then we move on to color of law. When an officer acts or purports to act in the performance of official duties under any law, ordinance, or regulation, they are acting under the color of law. So when you're in your official duties and you're performing your official duties, you're acting under the color of law. Then 18 U.S.C. Statutes 242 prohibits anyone acting under color of law from intentionally depriving another person of a constitutional or other civil right. Civil rights violations. A civil rights violation happens when an officer unlawfully interferes with the fundamental rights of another person, such as the right to due process and equal protection under the law. Law enforcement officers who violate someone's civil rights may be subject to civil liability and even criminal prosecution. So that is a civil rights violation. You interfere with the fundamental rights of that person. Officers who violate the civil rights of others may also be subject to discipline by the CJSTC, which is the Criminal Justice Standards and Training Commission, and their employing agency. Now we have agency liability, and we have two types of liability: direct liability and vicarious liability. Direct liability arises in cases where the officer committed an intentional or negligent tort in violation of the employee agency's orders and policies. The agency's liability is based on action it took or failed to take regarding an officer's alleged policy violation. So if they hired a problem employee, they assigned duties to that person that were not able to perform those duties, or they weren't certified to perform them, retention of a problem employee, so they didn't fire them when they should have, and failure to adequately train an employee. So that is direct liability, and the agency would take on that liability if any of these follow. So direct liability is specifically you doing something, but the agency could be at fault if they didn't fire you, basically. Then you have vicarious liability. This refers to the situation where someone is held responsible for the actions of another person. Vicarious liability involves the indirect responsibility of what officers do due to negligence in training, hiring, assessment, assignment, supervision, direction, and retention. So, for example, the agency would be liable if you get in a car accident because they hired you to begin with. All right, then we move on to limiting liability. There are federal and state laws that protect officers against civil and criminal liability and provide legal defenses, including sovereign immunity, acting within the scope of employment, qualified immunity, good faith, reasonable manner, justified acts, and emergency doctrine. So limiting liability just refers to all of these that I just listed, which are, doing what you can to limit your liability. Agency policies and procedures are developed and published for officers' benefit. By following such policies, you may avoid liability for acts done while on duty. So now we have sovereign immunity. Sovereign immunity is derived from the common law idea that the king and his agents can do no wrong. The sovereign law immunity law is 768 of the Florida statutes and is a limited waiver of this immunity. So sovereign immunity has to do with the state. So this has to do with state court. So sovereign is state. So S and S, remember, sovereign is for state immunity. This includes a list of circumstances and requirements that must be met before the state, county, municipal, or law enforcement entity or any of its employees can be sued in a state tort action. So sovereign immunity protects you from the state. It also protects individual officers and government employees from personal liability and for being named as a defendant in a state civil lawsuit. Scope of employment. Chapter 111 of the Florida statutes. If these actions occurred within the scope and course of the employee's employment, then you're good. Acting within the scope of employment refers to the range of reasonable and foreseeable activities that an officer does while carrying out the employer's business. If you do something under the scope of employment, the employing agency may, but is not required to, reimburse legal costs for its employees who have been sued or charged with a crime. The employing agency may provide legal counsel for its employees who are sued in either state tort actions or federal non-criminal civil rights action. Then we have qualified immunity. Qualified immunity has to do with protecting you from federal courts. So sovereign S for state, qualified immunity is for federal court. The defense of qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. See Harlow v. Fitzgerald. So with Harlow v. Fitzgerald, remember that Fitz is a Fed. So Fitz is a Fed, Harlow v. Fitzgerald. This has to do with protecting you in federal court with qualified immunity. Acts done in good faith. To act in good faith, officers must be faithful to their duty and honestly intend to avoid taking undue advantage of others. Acts done in good faith are without malice, ill will, or the intent to unjustly harm anyone. Acts done in a reasonable manner. Officers must act in a reasonable manner when responding to any law enforcement situation. Reasonableness is judged subjectively by asking if a reasonable officer in the same situation would have acted the same way. So acts done in good faith is just being honest and being true and not having ill will. acts does in a reasonable manner have to do with other cops saying, I would have done the same thing that he did. Then you have acts justified under the law. Some seemingly forceful and offensive law enforcement actions can be justified under the law. So, for example, you're allowed to carry a concealed firearm because you're a cop. You're allowed to use force in riots. And you're allowed to possess controlled substances during a criminal investigation. So things that normal people can't do, we're allowed to do. That's considered acts justified under the law. Emergency doctrine. When an unforeseen emergency requires instinctive action, you are not required to use the same degree of care as when you have time to reflect. This is known as the emergency doctrine. So if shit hits the fan and you don't respond perfectly, but you respond, in your scope of employment, et cetera, that is the emergency doctrine. They're not going to expect you to act perfect. Then we have the U.S. and Florida court systems. State judges in Florida are elected or appointed by the governor. Federal judges are appointed by the president. So state judges by the governor, the state governor, and Florida judges are appointed by the president. General jurisdiction allows a court to hear all kinds of cases within a geographic area, where limited jurisdiction is the power of the court to hear only certain types of cases. For county courts, there are 67 county courts which have limited jurisdiction and manage the following legal issues. So minor criminal offenses, misdemeanors, ordinance violations, civil cases, amounts of $30,000 or less, and then search and arrest warrants within the county. There are 67 county courts. Then you have circuit courts. There are 20 circuit courts, and they manage the following legal issues. These are kind of bigger. So domestic relation cases, major criminal offenses like felonies, probationary matters, cases involving civil cases with more than $30,000, Baker Act and Marchman Act. They can issue search and arrest warrants within the circuit, and they handle appeals from the county court judgments. The Florida District Court of Appeals, these are intermediate appellate courts of the Florida court system. They determine whether the law was applied correctly in the trial court, and these courts consist of 3 judges and do not use a jury. So this does not say how many district courts there are. So you have 67 county courts, 20 circuit courts, and then you have 5 district court of appeals. We were told it's 5, but it's not listed in the book. But it consists of 3 judges, and you do not have a jury for districts. Then you have a Florida Supreme Court. There is only 1. This is the highest court in Florida. It consists of 7 justices appointed by the governor. And the Supreme Court hears cases including final orders imposing death sentences and appeals from the lower state courts. Federal court system. U.S. District Courts. It's presided over by U.S. District Judges, and district courts are the federal trial courts assisted by magistrates. The Court of Appeals. These courts hear challenges to district court decisions from courts located within its circuits, as well as appeals from decisions of federal administrative agencies. Then you have the Supreme Court of the United States. This is the highest court in the United States, and the chief authority is the judicial branch. And these are appointed by the president. The Supreme Court's most important responsibility is to decide cases that raise questions of constitutional interpretation. This power is known as judicial review, which allows them to determine if actions violate Constitution. Okay, so personnel of the court. The judge. The judge presides over the courtroom and decides questions of law. The prosecutor represents the government's case. The defense attorney represents the defendant's case. The clerk of the court is elected, and they are responsible for maintaining files and official records and issuing subpoenas, and they assist judges. The court administrator. The court administrator is responsible for the day-to-day administration of a court system. A jury. A jury is a group of citizens who determine questions of fact in a trial. A bailiff. A bailiff or court deputy is generally a sworn law enforcement officer who is responsible for security in the courtroom. A court reporter. The court reporter is responsible for making a record of the proceedings. Then we move on to court proceedings, and we have 4 pages left. First appearance hearings. According to Florida law, the first appearance hearing must occur within 24 hours of the arrest. Hearsay evidence. This is information received from people that is not easily substantiated as admissible. However, hearsay is admissible in a first appearance hearing. So hearsay is not normally allowed, but it is allowed in a first appearance hearing. An arraignment. This takes place, the charges are formally filed by the state attorney's office. A pretrial release. A pretrial release, the defendant is released from jail pending the trial proceedings. And you have a bond hearing. At a first appearance hearing, there may be discussion regarding bond and special conditions of pretrial release. Deposition. A deposition is an official court proceeding in which persons involved, with the exception of the defendant, provide separate sworn testimonies regarding the facts of the case to one of the attorneys before the trial. Remember, with off the record refers to information not recorded in an official document. Always assume that anything you say could be used at a later time, even if they say off the record. Suppression hearings. A suppression hearing occurs when the defense files a motion to suppress or to exclude certain testimony or evidence from the trial, alleging that your actions were improper and violated their client's rights. Then you have a pretrial meeting. That's with the arresting officer, the witnesses, the victims, and the prosecutor to align your stories. Then you have a trial. The defendant selects a trial by judge or a trial by jury. Juveniles are entitled to a trial by a judge unless tried as an adult. Then you have a sentencing hearing. A sentencing hearing occurs after a trial. A sentencing hearing can occur before a trial. The defendant pleads guilty or nolo contendere. The victim speaks at a sentencing hearing. Violation of probation hearing. A violation of probation happens when an offender does not abide by all conditions ordered by the court. A violation of probation hearing occurs when an officer accuses an offender of violating his or her probation or community control and the offender contests the violation. Similar to pretrial hearings, VOP hearings are more relaxed. Hearsay evidence is admissible in violation hearings and can result in a finding by a judge of a violation if the direct evidence confirms the hearsay. So hearsay is allowed in a violation of probation hearing and is also allowed in one other. It is allowed in a first appearance. Okay, so a first appearance hearing and a violation of probation hearing, you're allowed to have hearsay. All right, Unit 4, Lesson 3, which is the last lesson, court orders. A subpoena is a legal order for a person to appear before the court, imposing a penalty if a person doesn't comply. A capias is a legal order for an arrest, so that's an arrest warrant. An ex parte order is a court order signed by a judge that is initiated by one person in the absence of, without representation of other parties. So you're going on someone's behalf to tell them, hey, they need help. A pickup order is a court order to take a juvenile into custody. So a pickup order is a juvenile warrant. Remember, a capias is a normal arrest warrant. A protection order is a court-issued order that is meant to protect a person, business, company, establishment, or entity and the general public from harm or harassment. A risk protection order is a temporary ex parte order or a final order which revokes a person's right to possess firearms. A domestic violence protection order is a court order issued by a judge to protect someone against domestic violence. Arrest by court order. You are required by the Florida statutes to tell the person the charge for the arrest unless, when it comes to an arrest warrant, unless the person flees or forcibly resists the arrest, you don't have to tell them, or providing the information will endanger successful completion of the arrest. Then we move on to serving a civil process. This is done by the Broward Sheriff's Office. So the Broward Sheriff's Office is the one who does them, except witness subpoenas or eviction notices. Civil processes can also be served by a municipal police officer or private server by authority of the chief judge. So when it comes to witness subpoena or eviction notice, that can be served by a city police. Okay, assisting in the execution of search warrants. Must be a felony to get one here. Before leaving the scene, make sure that all equipment and evidence are accounted for and removed after doing a search warrant. And that concludes Chapter 3.